Along with me discuss about the EB-3 to EB-2 porting, new interfiling guidelines from the USCIS, and the 485J supplement to be used for the porting the data from EB-3 to EB-2. Also, we were going to discuss about the statement made by USCIS that indicates that there are high number of green cards available under EB-2. We're going to discuss about whether or not USCIS is expected to use the 290,000 green cards that are available in this year. Emily, going back to the quoting the dates, Emily, we've been putting the dates historically by writing a letter to the USCIS, sending the information to the office which has pending the 485 application, and having them requesting them to adjudicate. And we were trying to hit the dot in the dark. I mean, there was no clear guidelines on it, how they are going to process that. There was no receipt notice, there's no filing fees. What has been changed right now?
Yeah, so on Friday, we have this mysterious update on the USCIS website, which interestingly didn't send out any email notification about it. Not a whole lot of fanfare. It's not a news alert on their website. It's just added this little statement that we have these additional green cards available in EB-2, and they strongly encourage you to file an EB-2 or to transfer from EB-3 to EB-2 if you're eligible. And they created a special process for that just for this fiscal year. So from now through September 30th, only for employment-based going from EB-3 to EB-2, we have a special process, which number one requires you to file at a new filing location in California that we've never been made aware of before. And it does specify that you need to submit the supplement J if you are porting to an I-140 and EB-2 that's already approved. And then they have updated their policy manual with more detailed information about the general transferring of different eligibility categories. This isn't just for EB-3 to EB-2 transferring, it covers everything, but that gives us a little more insight compared to what we had before.
Yeah, it's definitely a positive direction for the USCIS because the number of green cards that are available this year are very many, and it's very good that they created the system. Now let's look into the logistics of it, Emily. So when we file the 485 application, when we file the porting the date from EB-3 to EB-2, do we need to file the 485J supplement right now?
Yes, under this new provision, they've made it clear where the I-140 that you're porting to, your EB-2 I-140, is already approved. You must submit a supplement J to this new address in California. If that I-140 is pending, you do not need the supplement J.
For most of the audiences, I-140 for EB-2 has already been approved. So definitely they need 485J supplement. Is there any filing fees? Would they give a receipt notice, Emily?
There's no filing fees, but you do get a receipt notice for the supplement J.
Can the employees file the 485J supplement on their own, or has to be done by the employer?
It does require the employer's cooperation because of the supplement J. The employer has to sign that form confirming that the job offer that was listed on your EB-2 I-140 remains available to you and that they intend to offer it to you when your 485 is approved. And you also sign that confirming that you intend to take that job offer when your 485 is approved. So it does require the employer to be involved in that, getting that supplement J signed.
What if the individual has already interfiled? I mean, previously we used to send letters to the USCIS. Can they still do this? Do you recommend them filing a 485J supplement?
So USCIS says not to do it again through this process. I don't know if I trust that because we have no way of knowing if the initial interfile was actually accomplished. So I think I would be leaning towards going ahead and doing it again, following this guidance, and act as if I never submitted it before.
If we do interfile, Emily, can we use the EAD because EAD was approved under EB-3?
Yeah, so the good thing is the EAD is tied to having a pending 485. The category of the 485 remains C9, regardless of whether it's EB-2 or EB-3, so that EAD stays valid and you can use it.
Emily, if I interfile, means I filed an application in October of 2020. If I interfile, does it mean that I'm starting the application right now, or is it as if that it's been filed in October of 2020?
Yeah, in terms of processing times, it's as if you filed in October 2020. So you don't lose any of the processing that you've already accomplished.
I'm a bit confused about the filing fees and the receipt notice. You said there is no filing fees, there is a receipt notice, but in some of the statements of the USCIS, they said they don't issue a receipt notice. Can you be clear? What receipt notice are they going to issue?
Right. So for any interfile request that includes the supplement J, you get a receipt notice for the supplement J, but it does not say anything about the interfiling. And if you don't submit a supplement J, but you make an interfile request, you won't get any kind of confirmation, no receipt, no letter, nothing.
Emily, if I have filed the interfile and I have the advance parole, can I travel? Do you see any problem in it?
I don't see any problem with that. The interfile, again, is that advanced parole is tied to a pending 485 in the C9 category, which remains the same whether you're EB2 or EB3.
Will my medicals be done again?
Nope, no need to do that again.
I have an RFE for medicals right now. Can I interfile while this is going on?
I think there's a little bit of risk there. Number one, because they want you to interfile at this special address in California. And number two, you don't want them to mistake your interfile request as your response to the medical RFE and somehow miss that you've included the medical. So I think we would recommend respond to the RFE for the medical, see that the case status online update saying we've received your response to the RFE, and then proceed with the interfile under the normal process.
Emily, what if those people who have refiled in EB2, they filed in EB3 in October of 2020, it ended up in Texas Service Center, and recently in the month of December or January, they filed in EB2. Do you recommend them to do interfiling, or you want them to stay as they are?
Yeah, it's definitely a personal choice on that. The downside of interfiling now is it takes you completely out of the EB3, and so you only have EB2 pending. And some of the questions we're getting, what if EB3 starts moving again when everybody jumps out of EB3 and back into EB2? You just can't predict which one's going to be current first, and you don't want, there's a reason that you filed a separate one. You don't want them to be tied together and end up getting transferred to TSC. You want that EB2 to stay separate from the EB3. I think in many situations, so it would not make sense to go ahead and interfile because you've already done the refile to get the EB2.
Yeah, not at this time, but if we see a lot of progress in the USCIS where they're pulling all these files and approving the cases, we may change our opinion at a later date, but at this point of time, we are of a stand that most probably you should not do interfiling if you have both 485 applications though. Emily, what if all this 485J supplement, you're saying that it has to be done by an employer. What about the family dependents? Is there a 485J supplement? Is there a separate fees, or what do you do with them?
Yeah, there's no guidance about that. So we're kind of back to where we were before this guidance came out, because the supplement J does not ask any questions about family members. So when we're submitting our interfile request, we make sure that we include both the principal applicant's 485 receipt and the derivatives 485 receipts, plus your EB2 I-140 approval, plus the supplement J, and a very detailed and clear cover letter that makes sure that all of the derivatives are also included in this transfer request.
Why do they need the 485J supplement? Why can't they just approve it? Why I-140 EB2 is already approved. They have it. Why can't they approve it, Emily?
Well, it's the mechanics of USCIS. When you filed that 485, you submitted an EB3 I-140 petition. And I-485 can only be based on one category at a time, one I-140 at a time. It's not like they've got both I-140s there at their disposal and can easily choose one or the other. It has to be you that tells them which one to use. And by filing your 485 with the EB3 downgrade, you told them, I'm choosing EB3. Now you have to tell them you're changing your mind and doing EB2, so they won't do it automatically.
Emily, if they knew that the number of green cards are going to be plenty available in EB2 and they're not going to be available in EB3, why didn't these buggers move the priority date in October of 2020, Emily?
Yeah, that is the question of, I think, the year or possibly the decade. This whole thing has just been a debacle. They could have predicted all of this. We could have told them in October 2020, you're going to get all these downgrades, start processing them. What are you waiting for? And then they waste so many, and now they're wondering, well, what do we do?
So wait. You have these people file an extra I-140 application. Some of these people have filed an extra 485 applications for the entire family. Now you want them to file an extra 485J supplement. All this could have been avoided if they would have predicted. Had they just called us and asked us, what do you think so? How many people will do downgrade? We would have just said, yes, there will be a lot of people who will be downgrading. You should estimate that all EB2s are eligible under EB3s. All EB3s may not be eligible under EB2s. Most of them are not if they filed under EB3, but all EB2s are eligible under EB3, and they should have judged it though. Now there are questions that are coming up. What if now all the people who have filed in EB3 are now going to move to EB2? Will there be a backlog in EB3? EB2, sorry.
Yeah, I definitely think these dates are going to flip-flop again and again, and eventually they could end up at the same.
Yeah,
dates.
Eventually they will end up at the same, because most of the people we know of, Emily, at least 80% of the people that according to stats are an EB2. Only 20% of them are EB3 though. Obviously, a lot of the people have moved into EB3 now, so they're going to come back. So they'll be like flip-flopping. We'll be going back and forth, very similar to Los Angeles line.
Some other questions that have been coming up after this was announced. You did your YouTube show with TV Asia on Sunday and had tons of questions. So one of them is, once you have filed the 485 and now you're wanting to interfile, it says that you had to continuously maintain eligibility for adjustment of status. What exactly does that mean? Does that mean I still have to have my H-1B?
No, even if you have used the EAD, even if you have used the adjustment of advance parole, even if your family has used an EAD and advance parole, they can still do interfiling. The way that wording has been done is a little bit misinterpretation. They just have to be eligible for adjustment of status. That means that the final action date of the I-140 should be current. They will be eligible to file the interfiling. There's no requirement that they must be maintaining the H-1B or H-4 to interfile, Emily.
And if we do interfile, can we use the old EAD after?
Absolutely.
Before?
It can be used before, it can be used after. There's nothing that says that you have to be on H-1B. Even if you have used the EAD, even if you're going to use the EAD afterwards, you can still file the interfile application.
What are the situations where maybe you can't interfile or shouldn't interfile? What if your EB3 I-140 is still pending and they're not accepting your premium upgrade, or the employer is not willing to upgrade?
One thing is for sure, if the I-140 is being denied for EB3, there's no, you should not interfile the EB2, Emily. Now, if the I-140 is pending though, can you do the interfile? You can do the interfile, but I would advise against it, Emily. One thing is that the basics for the I-140 and 485 to be pending from October of 2020 is the I-140. If that I-140 has been denied, you may have a problem in getting the green card. Even if your green card has been approved, they may still revoke your green card though. I would strongly recommend that only those people who I-140 has been approved under EB3 should use the interfiling. Now, it doesn't mean that they cannot use it, but they are in a danger if just in case the I-140 gets denied. I would strongly recommend to get the I-140 approved and then use it. But if the I-140 is not approved, they will have to watch if the I-140 gets denied of the for the EB3, then they should be having an alternative plan.
Mm-hmm. Now, what if, there was a lot of controversy in October of 2020 about how to do a downgrade. Do you file it as a new I-140 petition, or do you file it as an amended I-140 petition?
Oh, a lot of lawyers have suggested that it should be filed as an amendment,
yes,
which we said that is a wrong statement and wrong thing, and then later on people corrected later on, yes.
So now, what if the I-140 was filed as an amendment? There are some reasons why you would have filed as an amendment.
Especially the company acquisition,
successor
successor of interest and company name change and certain other things. They may be forced. We have done some of those things too. But there are some lawyers who did a wrong thing by filing an amendment. If they want to do interfiling, Emily, they have to file an I-140 again under EB-2. And once that I-140 is approved, they should be filing the interfiling. They can file when the I-140 is pending also, but I would recommend to wait until I-140 is approved.
So you can't interfile yet, but you can file another I-140 and EB-2. Because you have to think about an amendment from EB-2 to EB-3 actually takes the EB-2 approval and turns it into an EB-3 approval. You don't have two approvals anymore.
Right.
You need to get back that second approval. So you can do that by filing yet another I-140. But that's
Can they do it because the labor certification has expired more than 6 months? You already used it for EB-2 and you have used it for EB-3?
Yes, you can use it one more time for EB-2. No problem there. All right. Other issues that have come up with this guidance that aren't really answered in the guidance. How does this work with the Child Status Protection Act? So what if the child's age was frozen based on the EB-3 I-140 approval and now the child is actually above 21? Can I do the interfile to EB-2 after the child has turned 21? Is their age still locked?
Even though this release has not given the guidance, though, Emily, when you look into this CSPA, Child Service Protective Act, it says that the child must be eligible based on the underlying I-140. So now the underlying I-140 is not EB-3, it is EB-2 though. So since the child is locked under EB-3 though, now he is moving into EB-2, the child is no longer locked in it, so the child will lose the status of CSPA and the child will be in a danger of not getting the green card. I would definitely advise people whose children are above 21 should not use the interfile, and if you are using it, you have to see how long the I-140 has been pending. I would definitely not address any of those things. If they're above 21 and they're already locked, Emily, they should not use the interfiling. That's a general statement that I will make. And if they want to, they can consult a lawyer, but definitely they should not do it.
What about a situation where the priority date is current in both EB-3 and EB-2 under the final action date and the child is currently under 21? Are they safe then?
Yes, they're safe because since the final action date is current right now, the child is still under 21. When you interfile, they're still safe, Emily.
All right, another issue that came up that's not addressed in this is what about someone who, after filing the EB-3 downgrade, got the I-140 approved, 485 has been pending for over 180 days, they switched employers under AC-21. Can they now interfile to get into EB-2 even though they're no longer with that old employer?
If the old employer is willing to support them for the job though, even though they are not working for company A, they are working for company B though, company A can still file the 485J supplement because the basis for the green card is not the employment, Emily, it is the offer of employment. If the offer of employment is still there with company A, they can still file the 485J supplement and support that. But only company A can do it. Company B cannot sign the 485J supplement for putting the dates though. For putting the dates they cannot.
Yeah, so if you wanted to proceed with company B only, company B would have to file a new Perm, new I-140, retain the priority date, and then you could interfile that I-140 approval.
Which is going to take about 1.5 years to 2 years, or you're just stuck with the EB-3.
All right, so what if I have a priority date in 2012, I've got my I-140 and 485 filed in September 2021 in EB-3. Should I now file an EB-2 in premium I-140 and then interfile, or stick it out with EB-3? If my date's current under both and I only have the EB-3.
So you filed September 2021, you filed the 485 application. Oh, that's a tough question though. It's going to be a tough question to answer because we don't know how this interfile system is going to work. We're not sure about it. So that will be an individual choice unless you have some other opinion.
I agree, yeah. What if, like we talked about, EB-3 ends up moving forward? Can I interfile again later to get back to EB-3?
So now you file the 485J supplement and then EB-2 backtracks and EB-3 back. Of course, you can do interfile again one more time, Emily.
Yeah. USCIS in their policy manual says that transferring amongst the employment-based categories is generally a simple transfer request.
Really?
And you should be able to do that multiple times.
Yeah, I disagree with them. If it's so simple, they could have approved all the cases that we have interfiled by this time.
Yeah.
But still, this is a welcome procedure that I would think so, Emily, what they did right now. the emails that our guys are sending to the council, to the representatives, to the USCIS, it's working because they've emphasized more focus on the employment based. And also, if you look into the processing times of Texas Service Center, Nebraska, and the National Benefit Center, the processing time of the employment based is way, way, way less than the rest of the other processing times, which is actually good news.
Yeah, and at least they didn't wait until August to
decide
this,
it, right.
like they did with the whole medicals last year, when they're all of a sudden wanting everyone to submit their medicals because the visas are going to run out on September 30th. It's as if they've never been through this year after year. It's the same thing every year, but this time they got it figured out a little bit earlier.
My priority date is March 2013, Emily, which is not current right now. Can I interfile right now?
I think you technically can. USCIS, in their announcement and in some of their new website updates, they've kind of given a little more detail about what they mean by the visa has to be immediately available. Normally in the past that meant final action date current, and that's it. Now they're saying it's immediately available if your date is current under the applicable chart of the visa bulletin, which could be either the filing date chart or the final action date chart. So if in that particular month they're allowing you to use the filing date, it's as if you're current to be able to do this interfile without waiting for the final action date.
MD, why does USCIS says that there are exceptionally large number of employment-based visas available in October for the employment-based 2 and employment-based 1st and employment 2nd section? Why couldn't they estimate that before? Why do they have to make a statement now?
I don't know. I mean, anyway, I could have told them that.
Well, no. We could ask any of our audiences there, and they would have told them.
Right.
They could have told. Now, based on the, you've been publishing on the Immigration Girl on the from the lawyer's desk, how many cases one particular lawyer have filed and how many approvals are there. What do you expect that they're going to use the entire 290,000 green cards that are available?
Well, I definitely think we're at a better pace than we were a year ago. So as long as they continue that, and if they don't dawdle on these interfile requests, where they've already done all of the processing they've had since October 2020 in most of these cases to do the processing, they should have plenty of time to approve all of the green cards that we have this year and not waste any.
Last year, they adjudicated in the first 3 quarters, Emily, only 75,000 green cards though. But in the last quarter, they adjudicated 85,000 green cards in the employment based. But if you look into the amount of green cards that they are approved in the first quarter itself, in our office in one particular lawyer's desk though, it looks that they're going at a very good pace, but I don't see that they're going at a pace of 290K though.
Yeah, they're not going at that fourth quarter pace.
But I don't know if this interfiling will change it. A lot of people are asking this question, hey, can you interfile? And the people have just responded to us saying that interfile it, do it by tomorrow. And okay, we'll try to do this as fast as possible. Can a different lawyer file the interfiling? That means, let's say, for example, I'm working with company A, my lawyer is ABC. Can you file the 485J for me?
Yeah, technically, yes. The 485J form asks who's preparing this form on behalf of the employer and who's preparing it on behalf of the employee. So if the employer allows you to select an attorney to prepare the entire form, then the employer would sign a G28 along with their portion of the supplement J. You sign a G28 as well, and then submit with that new lawyer. That is possible.
Anything else, Emily, before we go to questions?
I think we're ready for questions. We have a lot.
Manoj is asking question, is it mandatory for my spouse to be present in USA when I submit the interfiling request from EB-3 to EB-2? Absolutely not required. You can file without it.
Surabi says, with the number of interfilings coming up in the next couple of months, could EB-2 retrogress? I do think that that's a potential.
But though, Emily, when I look into the stats of the 485 applications that are pending, by September 30th of 2020, 21, there are only 290,000 applications pending though. So if they were to adjudicate the entire applications also though, they should be fine. Of course, there are more applications that will be filed in October, November, and December though, but still I feel that EB-2 should not go back. That's my assumption. And another reason is that right now the people who are interfiling are only between January of 2012 to January of 2013. We're not speaking about anybody who is before January of 2000. That means that by December of 2011, most of those people are not going to interfile. And the people who are filed afterwards, that means after January of 2013, they're not going to interfile. So it's only that one particular segment of people though. Another reason also I feel that it may not retrogress is because the unused green cards that come from EB-1 will fall into EB-2. The unused from EB-2 will fall into EB-3. So most probably there will be some unused in EB-1 that will fall into EB-2. So the availability of the green cards in EB-2 will be much higher than EB-3. And that's the reason where I may think so that EB-2 might not backlog. But I have gone wrong 1,000 plus, multiplied by 1,000 times. So I can still go wrong on it, but that's my analysis for it.
All right, Pyle says, my priority date is April 2014. I downgraded to EB3, received the EAD. If I change my employer using the EAD, what happens to my EB2? Can I refile or interfile if that becomes current? It all depends on the employer that filed that EB2 I-140. If their job offer is still available to you and you still intend to take up that job when you do finally receive your I-485 approval, everyone can sign the Supplement J and you can still take advantage of that EB2 even if you're not currently working for that employer.
Girish has this question: if I-140 approval takes more than 1 year, then the child is not an H4 and they're in, between 21 and 22. They're an F1 visa. Can they still file the 485 application? Girish, the child doesn't have to be an H4 visa to file a 485 application. If they meet the CESPA requirements though, you already know the CESPA, Child Service Protective Act, they can still file the 485 application.
IAPN has an EB2 I-140 approval from an employer that was acquired and filed an EB3 downgrade in November 2020, and he wants to know, can he use the EB2 I-140 to interfile as that date is current? Well, because you mentioned there was an acquisition of the company, that new company, in order to take advantage of the existing EB2 I-140, does need to file an amendment to show that they qualify as a successor in interest. So once they file that amendment, then you can do the interfile either based on the pending amendment or wait till it's approved and then do the interfile.
Aditi has a good question. For people who downgraded, would you suggest interfiling back to EB2 or filing a new AOS given the new communication from USCIS? Aditi, before we did the interfiling and refiling, we did not give a clear guidelines you should do the interfiling or refiling. We give the option open. We give all the pluses and minuses of the interfiling and refiling. Here though, since the new guidance have come out right now, it's still, we have to see, Aditi, whether or not this interfiling is going to work or not, how effective it's going to be, because the cases that we are filing in October are getting approved. October of 2021 are getting approved, and the cases that we filed in October of 2022 are still pending. So that bothers me a lot, whether we should refile or interfile. But it will be an individual choice that you have to make, Aditi. We can't say that, okay, do interfiling. If we say though, you do interfile, and then what if they don't honor it, and then the next door neighbor who refiled it, who files it, he gets a green card. I mean, it could happen the other way too. So it's very hard. It's a hard judgment for us to tell at this point of time, because this is a new system. If it works very effectively, where as soon as we file the interfile, they pull out the file and they approve the green card, that's going to be good. Then I would definitely say interfiling is better. But at this point of time, this is not tested. We're going to test it and we'll let you know. And keep following our YouTube and Facebook channel. We'll update you.
Yeah, kind of along those same lines, Ashok has a 2013 priority date, already filed the EB3, it's Texas Service Center, refiled an EB2 just a few weeks ago. can I interfile the old one to get into EB-2, and what are the pros and cons? What do we recommend? I mean, yeah, you can. There's nothing stopping you from doing that. You qualify for it. But should you? We don't know, if you do that, you lose the EB-3 option. And again, we don't know if EB-3 will move forward. Nobody knows. And this new process isn't foolproof. We don't know how long it's going to take. There's just too many unknowns right now. So I think you're better having your hands in both baskets right now. And we'll have to see how the interfile process goes to see if it's worth it.
Sudhakar's son is 19 years old, and I'm assuming that your final action date for the EB-2 is current. Should I interfile? Will it lock my son's age again? Yes, since your son is 19 years old and you're going to interfile right now, final action date is current. So he's locked in previous category, he's locked in this category. So it doesn't matter which green card you get it, he should be locked in.
Girish says, if the I-140 takes a year to get approved, does the H-4 child age out at 22 instead of 21? And if the AOS has not been filed, what are the options for a child who's beyond 21? So yes, you have until they turn 22 for the final action date to become current and file the 485, but their H4 age does not extend to 22. So their H4, they will still age out when they turn 21. So if you're going to take action to convert them to F1 without leaving the country, you have to do it before they turn 21. The CESPA age doesn't have any relation to your non-immigrant status.
Can we interfile on EB-2 and travel on EB-3 advanced parole? Is EAD and APP advanced parole tied to employment-based category? The answer is you can travel on EAD and advanced parole, absolutely no problem. The advanced parole and EAD is not tied to EB-2 or EB-3. As long as your 485 eligibility is there, you're good. You don't have any problem. You can use it if you want to.
Sumit has a pending EB-1C 485 at the Texas Service Center since November 2020. I-140 is approved. Priority date's been current for the last year. How much longer might it take? Yeah, we do see a problem with EB-1Cs at the Texas Service Center. I have a number from even before that are still pending. They've updated their processing times. I believe now they're saying for Texas Service Center employment base, it's anywhere from like 11 to 48 months, somewhere in that range. Now they've implemented a new process for calculating these processing times to where that first number, the low end of the range, is the point where 50% of the applications get approved by that point. And the other number, the high end of the range, is I think 93%. So the majority of them can take up to 4 years. It's pretty bad right now, unfortunately.
Karthi has a question. Do we need employer's signature for 485J interfiling? If the employer does not encourage interfiling, if the employer does not encourage or does not give permission, and then you absolutely require for an employer to sign the 485J supplement to file it, otherwise you cannot file it.
Neeraj has a priority date in November 2017 and wants to know if he should consider EB-5 as an option. How much time is that taking? We do have a number of people that are in the regular employment-based category and have an EB-5 filed as a backup plan. So that is a viable option, but it's not something that is going to provide you with any work authorization or travel ability until you actually receive that EB-5 green card. And the processing time to get to just having the EB-5 petition approved is anywhere from like 3 to 5 years right now. And only then can you finally file the 485. Once you get that 485 approved, your green card's only valid for 2 years.
Huh? Only 2 years.
Yeah, it's a conditional green card. So then you have to file another application to remove those conditions. That's taking another 3 years to process before you finally get the green card. That's a full green card. And a lot of people fail at that last stage because they didn't meet the requirements to remove those conditions. So there's definitely downsides to EB-5, just like there's downsides to having a 2017.
Well, good for immigration lawyers with all the processes. With all the 1 million, you're only getting a temporary green card. Emily, can we put the date from EB-3, EB-2 to EB-5?
Not EB-5. EB-1, 2, and 3, but not EB-5.
Arul says, my spouse has already used the EAD. Can we file the Intrafile? The answer is yes, you can. If I file the 485J supplement right now, and later on I move to a different company, let's say 1 year down the line, I move to a different company, can I still file another 485J supplement? Will it cause any problem? Absolutely, you can. That's definitely when you change the company, you can. You will be fine. You will not have any problem in it.
Gayatri wants to know about an H1 transfer or a conversion to H4 EAD. Her husband was laid off, and she wants to know, should he immediately try the H4 and EAD based on her H1B status and approved I-140, or wait and try to find an H1B job that he can transfer to? Really, you could do it either way. The good thing is you do have the 60-day grace period. So you could take those 60 days to try to find another job to be able to file an H-1B transfer. And if on day 59 it doesn't look like an H-1B transfer can be filed, then you can file the H4 and H4 EAD change of status without losing your status during that. So that's one way to go about it. The other way is to go ahead and file the H4 and H4 EAD because the processing time is so long. You don't want to lose those 2 months of processing times. And if you do end up getting that H-1B job before the end of the 60 days, go ahead and file a transfer and withdraw the pending H4 and H4 EAD.
Do we need to redo the fingerprints and medicals? No. No medicals again required. No redoing the fingerprints for refiling. Does the receipt of 485J mean an officer has been assigned to the case? No. No. I wish it was. No. That is not true.
Ronald says the I-140 amendment is filed and still pending. Is there any risk for interfiling back to EB-2? So assuming you mean the I-140 amendment also was an EB-3 downgrade, so the downgrade amendment is pending. That also means because it was filed as an amendment, you technically don't have an EB-2 unless you were to withdraw that amendment before it gets adjudicated. But withdrawing it is going to mean your 485 is not available and you have to refile. So really what you're looking at is filing another EB-2 I-140 and only requesting the interfile back to EB-2 after the EB-3 amendment actually gets approved, because there is risk there.
Carl Rowe, 2021 move from EB-2 to EB-3, 2022 EB-3 to EB-2. What will be 2023?
Oh gosh.
This is definitely a miscalculation. We've been telling that they should have been moving the dates way in advance. They did a complete miscalculation, complete mistake. When the processing times are so long, I don't understand why they didn't move the priority dates well ahead though. Why did they have to wait until September of 2020 to move the dates? They could have moved 6 months before, because they're not going to adjudicate the cases. Just date of filing can be moved and final action date doesn't have to be moved. It definitely is, Carl Rowe, I do agree with it. This is definitely a lot of going back and forth unnecessarily. If they move the dates all the way to 2018, they wouldn't have faced all these things. They would have just moved accordingly, and probably a little bit switch of EB-2 and EB-3 lanes will be a month here and there, but definitely this is not the better way of handling the situation. Can the employee file 485J supplement by themselves, or can be done by company? It should be done by company attorney, but you can, if you want to, you can choose your own lawyer, but your employer has to sign and has to authorize it. Can the fees be paid by an employee, or does it have to be paid only by the employer? Lawyer fees. Lawyer fees in the 485J supplement can be paid either by employee or employee. There is no requirement, just like the way you have for the H1B or Perm labor, there is no requirement that it has to be paid by the employer only. There is no requirement like that.
Arul wants to know, if my spouse has already used the EAD from the AOS, can we still interfile? Yes. When the spouse uses the EAD from the AOS, you can't file a second 485 because they're no longer in the non-immigrant status, but you can interfile because you're transferring the existing 485.
My daughter will graduate in May 2022. My question is, can she file the H-1B lottery? Yes, she can file the H-1B lottery as long as by the time of filing the H-1B application, she has completed the coursework that is required for it. Then she would be eligible for the quota in this year.
Ravi Kiran says the EB-2 I-140 approval from Company A was downgraded to EB-3 by Company B as a successor in interest and concurrently filed the adjustment of status. Can I now interfile with EB-2? For that, you first need to have another EB-2 I-140 filed as an amendment not as an amendment, second EB-2 I-140 filed for successor and interest using the same labor certification, and then once that's approved, you can interfile.
Question that came is from Meda 111. How many 485 applications are pending to be adjudicated in EB-2 and EB-3? Meda, they haven't given the description of whether the 485 applications are pending on EB-1, 2, 3, 4, 5. They haven't given it, but the total number of 485 applications pending as of September 30th of 2021 is approximately around 290,000 green cards.
SKR 25 says, does the receipt of the 485J mean that an officer has been assigned to a case? I don't think so.
Yeah.
We don't have a lot of the, the inner workings of what goes on. But
just by receipt, it does not. I mean, when the application is received, though, it's a contractor who inputs it, and then it has to go to an officer, though. I have personally visited service centers, and the way it works is that, I mean, it's a Walmart size mail processing thing. When the mail comes in, and they are processed it, they're scanned, they're put in the proper place. Then the officer get to pick it up, and when the officer get to pick it up is not going to be decided immediately, though. But the receipt notice will be issued immediately. Did you address the issue that the person who wants to get his spouse on a B-2 visa while he has a green card holder?
No, I did not.
We definitely recommend, if you are a green card holder and if your spouse is in India, we recommend that they do not apply for a B-2 visa. The reason is that if you apply for B-2 visa, you have to express your intention whether or not you're going to come here only temporarily or you're going to come here permanently. Since your spouse is a green card holder, that shows that your intention to come into the United States, though. So B-2 and F-1 are not recommended, but if the person is eligible for H-1B or L-1, because they're dual intent visas, they can come on it, but definitely not B-2 or F-1 visa.
Nitin has an interesting question. He's the derivative on his wife's 485 and EB-3, but her priority date is not current. He has his own I-140 and EB-2, which is current. Can he transfer to him being the primary on the basis of EB-2 and her being the derivative? Yes, you can.
I would not suggest that. I would not suggest it. The reason is that it's going to confuse them. And one of the other things that I need to look into is that whether or not he was eligible in October also when they filed the 485 application. So when I did these kind of things, Emily, I have had results after 5 years or 6 years. I refiled the entire application. The refiling application got the approval, though. And the same question is coming on the family-based 485 and employment-based 485. Unless you go to the interview and the interview officer will allow you at that point of time, though, I strongly recommend you refile the application if you're eligible for it, because it's going to confuse them. They are very confused. This interfiling system, they just got this interfiling system right now, so I don't want to confuse them on that. Can we send the medical with Interfile? That's a good question.
Send the medical with the Interfile.
Why not? You can.
Well, I don't know, because it goes to that different address. Then how are they going to get it to the officer? We don't know what they're going to do at this other address. Are they just going to notify the officer in Texas that, hey, we got this? Or are they going to just forward it to Texas? Or are they going to...
Yeah, it may be better that you interfile in a regular interfile process for medical. One of the things that I'm thinking about, Emily, is that when the 485J supplement is gone, though, I mean, there's not much mechanical work if they can assign, if they have a designated officials there who can review the 485J supplement. All they need to have is that link the I-140 file there after checking the signed document of the employer. So your point seems to be well taken with regards to not sending the medicals, because this is going to a different address. And the people who are going to open this mail are more proficient in only handling the 485J supplement though. So I would rather want my 485J supplement to be opened, and they should not be referring this to somebody else. What happened in October of 2020, when we started filing I-140 and 485, there are some officers who can adjudicate the I-485. There are some officers who can adjudicate the I-140. But how many officers are there that can adjudicate both the things together? Very less number of people, and that's the reason the whole Texas Service Center is just a mess right now. So if I have to take that principle, though, you're right. I would rather segregate the medicals and the interfiling of the 485J supplement, because I want this officer only to do the 485J supplement, not mix it, and then they'll get confused. You know, a lot of these people who open the mail, actually all of the people who open the mail and process the mail, Emily, actually they're not USCIS employees. They're actually contract workers. They're not trained in anything. Just do the mechanic, just like a parrot work there. Anything different they see, then it has to go to somewhere else, and then it's going to take a long time for them to get anything. So yeah, it probably is better to file the medical separately.
Priya says, my current employer didn't file my labor. Can my ex-employer, who has the approved I-140, still file the 485 when my date is current? Remember, the I-140 and the labor certification is based on a future job offer that you intend to take at the time you receive the green card, and your employer offers to you at the time you receive your green card. It does not require current employment. So if that job offer is still available to you, which is shown by that employer signing the supplement J, and you intend to go back to work for that company once you get your green card, which is what you intend when you sign the supplement J, then you can proceed to file that I-485 based on the old I-140.
Will the Centerfile work when we have EB-2 and EB-3 Perm approved from a different employer? Yeah, I don't see. It should work. We don't see any problem in it.
Yeah, I mean, if you go back in the day when everybody was EB-3 and they had their I-140 approved, they filed the 485, and then everything retrogressed. Those people later became eligible for EB-2 because they either gained 5 years of experience or got a master's degree, changed employers, filed a new labor, new I-140 and EB-2, and then interfiled. That's what we did back then.
Yeah, especially for a lot of people where we moved from EB-3 to EB-2. Received 485J supplement notice fees. It says fee waived. What does this mean? It doesn't mean anything, Puru. It means that they just received your 485 application. If you file 485J supplement along with the 485, sometimes they do issue the receipt notices. Sometimes they do not issue the receipt notices for the 485J supplement. However, when we file a standalone 485J supplement, the standalone 485J supplement we file when there is a change of employer, and now we have this new system called Intrafiling. They will issue the receipt notices. In their information, USCIS information on website, they have clearly indicated that if we file a 485J supplement, they are going to issue a receipt notice.
A couple people have asked kind of how the mechanics are if you refile in EB-2 after you've already filed in EB-3 and are waiting on your EAD or AP to process. What happens once you file that second 485 to the EAD and AP pending based on the first one? Well, when you file the second 485, we recommend to include another EAD and AP application in that, because that'll be tied to the second 485. The first applications will continue to be processed as if you've never filed the second one. So everything will process as usual. You might end up with 2 EAD APs, nothing wrong with that.
Any chance for the immigration reform this year? Definitely the big bill is dead, according to me, Emily. The only chance, I mean, very rare that it will be alive. The only chance that I can think about right now is probably the per country limit taking off. There is a slight chance for that to get passed. Maybe most probably there is a chance for it, but I would give not very high hopes, but there is a chance for it. I would suggest that we're coming up with the letter, which we are going to publish it in a week or so. It's almost finalized. This administration is trying to do a lot of good things, though. We just want to do one more good thing, and that is that the INA section, when the Congress passed it for the 140,000 green cards, doesn't specify that the family members need to be counted. So it's up to the discretion of the executive, that which is the administration, to count the family members. So we will draft a letter. It will be published soon. And all we need is that if the administration stops counting the family member, then we don't have to worry about all these problems. Because if the family members are not counted, the numbers will go from 140,000 to 300,000 green cards, and it's going to be it's going to come almost like within one and a half year waiting period. Everybody will be current in the next 2 years if that happens. So we'll come up with it. I hope you all will support and keep writing letters to the congressman.
Tom has a downgraded EB-3 from 2020, has the EAD and AP, and wants to know if he travels using the AP, will it invalidate the EB-2 I-140 and he loses out on this interfiling if his priority date becomes current? No, it does not invalidate that I-140. The I-140 remains valid until it's either withdrawn by the employer or revoked by USCIS. So travel does not invalidate it. But if you're no longer maintaining your non-immigrant status, you lose the option to file a second 485. You can still interfile to transfer the existing 485 from EB-3 to EB-2.
Amrinder forgot to attach the pictures with the H4 EAD application. Can I send the pictures to the same service center? One thing I would recommend is just refile it. That's one thing. Second thing is that you can try the interfiling, but use the word interfiling and send the receipt notice along with it, the 765, and try to see if they would attach. But I would just refile, because you never know how long they're going to take to issue an RFE.
Pavan Kumar wants to know how long is it taking for prevailing wage determinations right now with for the Perm process? Anywhere from 5 to 7 months. They are not getting any better.
People are asking about the priority days projections. So definitely, we have seen positive signs from the USCIS in the adjudication in the last quarter of the 2021. That's from July, August, September. They did adjudicate a lot of application. Even in the month of October, November, and December, they did adjudicate a good number of applications. If they go in the same pace, though, we may see some improvements. And we are also expecting, because of the COVID going around the world, the family immigration, some of the unused family immigration may still fall into the employment based. So that may occur. So we may expect some movement. They should have moved. I don't know. I mean, look at the struggle. They're telling in their letter that there are numerous employment-based immigration green cards available. Dumb guys, did you not know that? I don't understand it. So definitely we have seen some changes recently, especially in the last quarter and going forward. We've seen this interfiling thing. We may see some more changes, and hopefully so they will act on it and they will adjudicate the applications. And surprising thing, Emily, is that we are in the month of February right now, and they are accepting the filing dates. It never happened. October, November, December, January, February, 5 months of filing dates never happened. That is also a very positive sign. Now the question is, the Department of State needs to be caught up with the USCIS. They need to move the dates instead of moving it back.
Yeah. Santosh, his daughter applied for a change of status from H4 to F1 and wants to know if she needs to go for biometrics. Yes, so the I-539, if you're filing for an F1 or a B2, that biometric is still required. You still have to pay that $85 fee, and you will get that appointment. Only the H4 and L2 had the biometrics waived. or suspended, I guess.
Hardik Patel has this question. Do you recommend to use the EAD and advance parole, or do you recommend to be on H-1B and maintain the H-4 status though? We put a video on whether or not you should move on to the EAD and whether or not you should maintain the H-1B though. It's about a 10 minutes video. I want you to watch it, search it in there and search it though. I personally, when I was on a H-4 visa though, I have used EAD. I let my H-4 void. If I would have not used the EAD, and believe me one thing, I would not have been an immigration lawyer, because the offer of employment that I got it was on EAD. Nobody was willing to file for me on a H-1B at that point of time to work as an immigration lawyer. So I have used EAD, and that's why I'm an immigration lawyer. So it's the wrong guy. I mean, if I would have not used the EAD, I would not have been an immigration lawyer. I would have been somebody else. I got an opportunity only because I had an EAD. A lot of people lose the opportunity because they want to cling on to the H-1B and H-4. Now, there are some minus points if you were to use the EADs. Very less minus points though, but I want you to watch that video that we put it about 2-3 months ago. It's H1 or EAD. That's the title that's there.
Sudhir, my attorney said that we can interfile even if we selected amendment during the downgrade process. You know, an amendment means you're taking the existing approval notice and changing it to whatever you've amended it to. So if you're amending it because of successor and interest, you're taking the existing approval notice and changing it to the new employer. If you're amending it and also downgrading it at the same time, the initial one doesn't exist anymore. It's been changed into this new one. I don't think you have the option of interfiling in that case because the EB-2 no longer exists. It's been amended to now become your EB-3. You need to file a second I-140.
Sahil Kaur has this question. My GC interview is scheduled next week, and my priority date is backlogged. Shall I do the interfiling after the interview? No. Do the interfiling, take the interfiling with you to the officer who is interviewing. First thing is, go ahead and file the interfiling right now in the mailing address if you can, but take it to the interview. They can adjudicate it. It's not absolutely needed that you have to only file with the California address. You can take the interfiling thing and take it with you to the adjudication officer. The adjudication officer has the discretion to change that into EB-2 and approve the green card at the same time. Question that is here is, my daughter is 16 years, got an EAD and the adjustment of status. Can she use the EAD? Yeah, why not? I mean, they are eligible to use the EAD. Absolutely, they can use the EAD.
Balachandar, why do we need to send the supplement J along with the letter when the USCIS site says if required? What do they mean by if the supplement J is required? I know that section that you're talking about, it tells you that the interfile needs to include the supplement J if it's required. Well, in another section, it tells you when it's required, and that is if you are filing based on an already approved EB-2 I-140. You need the supplement J. If your EB-2 I-140 is pending or filed concurrently with that interfile request, then you don't need the supplement J. That's what they're referring to there.
But it's always good to follow the directions what they have given rather than counter it though. If you file in 485J, we get a receipt notice, we have a tracking that it's been filed under EB-2. It's always better to do that.
All right, so I think we are out of time for today. Thanks so much for joining us, and be sure to join our daily conference call if you have more questions, and you can always sign up for our newsletter at rnlawgroup.com.